Yeah, hello everybody. It's nice to have you here again. And chapter 1.4 of International Inheritance Tax is going to deal with some economic consequences of that tax in international competition and the conclusions which one perhaps has to draw from that for the optimal structure of such a tax. Well, here's first an overview about the effects which we have at least to take into account. The first thing naturally is if they are subjected to an inheritance tax, businesses lose equity at a certain amount of time. There might be problems in international competition if businesses of different countries are subjected to different tax rates and similar things. Let's begin at the beginning. So with the effect that equity is lost, as you see, when an inheritance tax occurs, we will have a negative effect on the equity because your equity, your net property will be tax based. A certain percentage of it, let's say 10%, 20%, or 30%, has to be given away to the state. So suddenly and probably at an unforeseen point of time, you have to give away, let's say, 30% of your equity to the state. So ratings in the future will go down. You will have a need for additional liquidity, and that must be dealt with relatively quickly. The first important question people from business always ask when it comes to competition chances: will the tax have comparable effects for sole traders, partnerships, and capital companies? The first idea usually will be yours and mine, that capital companies never die, and so that they are out of the scope of inheritance tax. But this is only half of the truth, because the value of a capital company is represented by shares. The shares are held by natural persons, and these natural persons in the course of time tend to die. And so there will be taxes due on the value of the shares. And like any other business owner, a partner or a sole trader, the holders of the shares will need to withdraw money from the enterprise in form of dividends in order to be able to pay for the tax, or they will have to save up money in a corresponding amount over time before this happens. So they will have to withdraw more money to compensate for the tax. So in the final effect, there is no huge difference. Well, but at least you see one difference. If you have a sole trader, then all the equity belongs to one single person. So if that one and only owner dies, let's say 30% of your net equity have to be given to the state immediately, or within a month, or within half a year or so. So a huge loss of equity happens at one and the same time. Whereas in case of a partnership, you will probably have that effect a little bit distributed over time, because there you have equity of partner A and partner B, and now when A dies, half or 30% of his equity is gone, and partner B dies considerable time later, and then 30% or 20% of her equity are gone. So one can say the more partners exist, the more equally and constantly the effect is distributed over time. So there is probably not a different taxation of different legal forms, but depending on the number of shareholders or partners, who are engaged in a firm, you will have a different economic effect with regard to that sudden loss of equity. With more people, not so much equity is destroyed at the same time, so that could probably help you. Then when it comes to the effects of international inheritance tax or inheritance tax in an international arena, then the first question should be, how can we analyze the effects in an adequate way? Because our principal problem is, if you compare a business in Germany with a business in Spain, how can you compare businesses in a way that you can be sure that they are comparable? Usually when you go to textbooks on microeconomics or macroeconomics, then you see that economists have a very nice trick. They usually just analyze things on the basis of a so-called ceteris paribus analysis. That means you just assume in your model that apart from the one and only aspect which you are interested in, all other aspects, all other consequences, all other circumstances are absolutely equal. You define them as such. So for the economists, they would just say, we compare a factory for cars in Germany with, by definition, 10,000 employees with invested capital of, let's say, 100 million, blah, 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 and so on. Everything else identical to a car factory in Spain with the same number of employees, the same amount of invested capital, and so on, and so on. And then you can analyze what impact a different inheritance tax or any other different factor would have on the fate of the enterprises. Now, unfortunately, when you look to reality, such ceteris paribus models lack one important condition. They are absolutely not realistic. They cannot happen in real world, because a factory in Spain is different from a factory in Germany. Different places, different productivity of employees, different labor laws, different behavior of trade unions, and so on and so on. So you will never find two identical enterprises in reality. Now you could say, but it's only a model to simplify things. Yes, but if you simplify things, you should not simplify them in a way that the findings cannot correspond to reality or have no bearing on reality anymore. If you just say, let's compare a man and a woman, and then define that there are no differences, or analyze that based on the assumption that both are absolutely the same, that is probably not really realistic. And so better would it be to find a model for analysis where you can allow for the possibility of differences between the two locations or so, and nevertheless can find out if there are distorting factors. So that is what we have to look for. And if you now take into account that at different places you will perhaps have different conditions, then we should at first define or take into consideration that our enterprises A, B, and C in different states will be different at the different locations. Because let's say a hotel in Spain has different weather, different guests, and so from a hotel in Germany, in Bavaria. So here my model shows you let's say we have the same assets, the same debt, the same equity in 3 states, so the same invested capital, then the productivity will already be different. So it might be that you have in state A 20% rentability, so you make a profit of 100. The income tax rate there shall be 50%, so your net profit is 50. In the enterprise in country B, it might be that the productivity, the local one, is only 15%, so you produce 75 units gross. If the tax rate there is 33.33%, then the tax would be 25%, the net profit 50. And enterprise C in country C would have perhaps only rentability of 12.5%, so would earn 62.5, would pay a tax rate of only 20%, and then you would have a net profit of 50. What does this model show you? Well, this model can explain to you why investments at different locations, although the factors at the location, the productivity factors are different, can nevertheless end up with comparable results and can be competitive. Here I showed you that it is and why it is possible that at different locations you can invest with different tax rates, although in the end it might happen that there is no distortion of competition. The underlying idea or explanation is, if you invest capital, let's say if you invest 500,000 euros somewhere, you cannot opt to choose just the factor taxation or the tax law of Spain. You can only opt for the whole bundle of factors which determine your productivity and net outcome in Spain. And if the outcome of that factors is comparable to the overall outcome of the productivity factors in country B or in country C, then competition can still work. So you can analyze with such a model that, or explain at least, why, although we have different tax rates in the world doesn't break down, or that even in the long run, not all enterprises of one certain country die out because the others have a better tax rate. So now when we can understand that in a world of different places with different productivity factors, different local laws, different tax rate must not necessarily bring along bad chances in competition. We can go on and try to analyze what does that mean for the impact of inheritance tax. So let's look what an inheritance tax would do to a world which is defined as I defined it just now. So imagine we define enterprise A as an enterprise based in state A. And now the trick is to make the two enterprises comparable. We just say that they don't do the same thing at different places. We just define that they do the same things at the same places under the exactly same conditions. And now this is possible. A German enterprise can own one car factory in Germany and one car factory in Spain. And now you will see that if you run a car factory in Spain, you will have the Spanish investment conditions, even if you are a German firm. So by definition, we let our enterprise A from, let's say, Germany become active in both states which we compare. Germany and Spain. So we have to deal with the productivity factors of both states. And now the trick. Enterprise B from the other state, for example from Spain, is now defined as doing exactly the same things at the same locations to the same extent. So Enterprise B, for example, from Spain is defined as having also one car factory in Spain with exactly the same dimensions as our car factory there from our German enterprise. And Enterprise B also has another factory in Germany at the same place, in the same town, where we also assumed that car factory of our German enterprise A. So now, by definition, we have created a realistic situation where in the real world, really enterprise A and B have all the other factors which are relevant for productivity identical. So this is a realistic ceteris paribus analysis, because even in an international arena where many things are different, at every different place you have a different legislation and different workers with different qualifications, trade unions with different amount or grades of aggressivity and so on. Yeah, all that can now be realistically assumed as being identical. And now we can analyze if the rules of taxation really bring along a difference between enterprises A and B. And now, if in this, or because if in this specific model all other factors are really realistically identical, we can identify if tax influences create a distortion. And if there is a distortion, we can try to analyze if that distortion can, within that model, so under realistic circumstances, ever be compensated by any other effect. And usually that can be seen by logic. Usually you can assume if all other factors are completely identical, then there can be no compensation, because where could it come from? Huh? It could only come from differences in other kind of legislation or so, but usually they are not there. So here we really have equal chances. And now let's analyze what happens if we have inheritance tax law. We have already deduced in our first chapters that probably the tax rates will be different, and second aspect, that every state which practices inheritance tax in a reasonable way will always apply only the credit method and not the exemption method, because that would give completely wrong incentives. So if we assume that the A tax rate is 50%, this will be applied on the worldwide property of enterprise A, and in state B, if there the rate is 20%, they will apply it to the worldwide property and then credit the foreign tax from state A. So the result will be the following. Enterprise A will be subjected to a 50% rate in its home state on its home state permanent establishment, so on the head office. I assumed there will be an equity of 1 million in my example, so half of it is gone and 500,000 is left over. Now they also have a PE in the other state, permanent establishment. I assumed here just arbitrarily that the capital invested there is 2 million. So 50% tax taken away from that is 1 million. Now, state B, as I said, also levies an inheritance tax. Their tax is 20%. Now, we have already assumed, and that is a realistic assumption, that double taxation shall be avoided by the credit method. So the 400,000 of State B can fully be credited to the tax burden which is demanded by State A. And so in the end, 600,000 go to State A, 400,000 go to State B, and the effective tax burden for this PE is 1 million. So 1 million equity there is left over. So after that inheritance tax case, Enterprise A has its equity reduced to a total of only 1.5 million instead of former 3 million. Now, Enterprise B is defined exactly as the same enterprise doing the same things at the same places, but only resident in State B. So before every catastrophe starts, they also have an equity of 1 million invested in the PE in State A and 2 million invested in State B. Now, under their unlimited tax liability, they will be taxed with 20% everywhere. So home state claims 200,000 on the A permanent establishment. Now, State A taxes them with 50%, that means 500,000. So in the end, the higher amount prevails, so there they will have to pay 500,000. So as in the case of Enterprise A, only 500,000 will be left over as net equity invested there. Insofar, we don't have a difference. But now we come to the PE in State B. There they have before an equity of 2 million. Now this is not covered by the limited tax liability of State A, but only by the unlimited tax liability in State B in our case. So 20%, that's 400,000 are claimed. Foreign tax is not claimed, so we remain here with 400,000 tax, and the remaining equity will be 1.6 million. So that Enterprise B, after the inheritance, is left over with a total equity worldwide of 1.6 plus 0.5, that is 2.1 million equity. So that's considerably more than Enterprise A has left over. And the effect is simply and only due to the different residents of the two enterprises. As we have defined a ceteris paribus situation which is realistic, so that all other aspects are identical for the two enterprises, and we have done this in a way where natural differences like the weather, the different qualification of the workers, and so all this is realistically defined in a way that it can have no impact on the analysis anymore. There we have a pretty good case for a distortive effect of inheritance tax on competition, which can, in contrast to the different income tax, which we had analyzed here, which cannot be compensated because enterprise A, B, and C here can, due to their different other productivity relevant factors at the different locations, compensate the influence of the different tax rates. That cannot be done anymore in this situation where we defined the locations where the enterprises earn their money as exactly the same in a realistic way. So here we can see, okay, inheritance tax just creates indeed distortions in international competition, and these distortions are a problem because under realistic assumptions, there is no way to compensate that. Now, how will people react to that? That's the simple question. Well, what will a caring state do for its enterprises? Well, we have seen that the higher your tax rate is for inheritance tax, the more your people, your enterprises have a disadvantage in competition. And if you don't want that, in the long run, it might be highly damaging for your economy. If you don't want that, then there is only one consideration, which is really convincing. Just take care that your local tax rate is the lowest. Then the difference in the tax rates can do no harm to your enterprises, but will do harm to the enterprises of the others. So every state should have an interest in applying the lowest relevant inheritance taxes to its own enterprises. And now, surprise, ladies and gentlemen, although nobody ever said that this should be observed in tax policy. That is exactly what has happened during internationalization during the last 30 or 40 years. The inheritance tax rates for business property everywhere strongly dropped down. There has been a race to the bottom, as exactly as a theoretical analysis would predict it. Many states have already ended up with a zero rate or an effective zero rate on business property. So that seems to be convincing if you have such a competition, and if different rates cause a disadvantage, you have the choice only to choose between either kill your enterprises and eliminate them from competition in the long run, or giving in concerning the tax rates and lowering them down more and more and more until in the end you end up with a zero rate. So you abolish a tax which in the beginning we regarded as desirable under the aspects of the ability to pay principle. The only way you could escape from that would be a harmonization of the tax rules for inheritance tax, so that the states involved would agree on identical tax rules. Now, in the area of income tax, we can live with different tax rates, and our analysis some slides ago just showed you why. Because there you have different factors at different productivity at different locations, and if you, for example, opt for the exemption method as a legislator, then you end up with no distortion. So the same people doing the same things at the same location can act under the same circumstances, so competition can be fair in a real world. But now we showed you already that an inheritance tax can only function properly if you not apply the exemption method but the credit method, and then the situation is completely different. If you then have different tax rates, then you end up necessarily with a distortion which can never be compensated again. And so the only alternative to a zero rate in the long run would be a harmonization of the tax rates and tax rules, for example, within the EU or even on a worldwide scale. That should motivate us to have a look to the next chapter. Is there any relevant EU legislation? You already know, ladies and gentlemen, that within the European Union, the power to legislate on taxes is in principle still with the member states. But as with other legislative activities, the member states have to refrain from any activity which has negative impacts on the rules of EU law. For example, if EU law demands a free flow of capital, then a member state is not allowed to make any legislation which creates avoidable obstacles for that free flow of capital. So EU legislation might be something interesting here. And as we just found out that a harmonization of the tax rates is in the long run the only conceivable way to avoid a zero rate everywhere, we should also have a look if that could be made under EU law, if the existing EU framework would allow a harmonization of taxes. So let's begin perhaps with that point. Then we might add some small excursus about constitutional problems in Germany concerning the exemption of business property but the full taxation of private property. One should also mention problems with regard to EU state aid rules, which might surprise you. And last but not least, the relevance of the fundamental freedoms of EU law. So let's start. Is there the possibility for the EU to do something like harmonization of inheritance taxes? And the answer is a clear yes. If you look to Article 115 on the Treaty on the Functioning of the European Union, then it tells us that without prejudice to Article 114, so without damaging or without having any negative impacts or restraining the competences laid down in 114, the Council also shall, with a 100% majority, issue directives for the approximation, so harmonization of laws, regulations and administrative provisions, so any legal rule of the member states which directly affect the establishment or the functioning of the internal market. So if you have negative, distortive effects of any legal measure to the functioning of the internal market, and we have already seen that is the case with inheritance tax, then the Treaty on the Functioning of the EU allows the EU to make a harmonization directive which gives binding orders to the member states to agree on at least a set of rules which either eliminates these distortions or limits them to an extent which is no longer really damaging. So a directive on all competition relevant aspects of inheritance tax would be possible legally under Article 115. Now the problem is the necessary majority. You would need 100% majority in the Council, so every single fiscal minister of the EU would have to agree. Before the EU Commission would have to make a proposal, because the Council does not have the right to start a legal initiative. And that's it. Now, the 100% majority in the EU is difficult to obtain because at the moment 1/3 of the member state have no inheritance tax at all, approximately. And so the fiscal ministers from those states would probably not agree on a harmonized inheritance tax within the EU at a rate which is different from zero. So at least that would be a political risk for them and their prime ministers who appointed them. Might be that they get beaten up in the next election if it gets known that they voted for an inheritance tax, and might even endangers the situation, the popularity of the EU in these countries. So it's highly improbable at the moment that you get the consent, the necessary consent for such a harmonization directive of the EU. Nevertheless, it would be necessary and it would be allowed under economic aspects. Yeah. And by the way, the EU Commission has never even started an initiative to harmonize the inheritance tax legislation of the member states, not even with regard to business property, because they did not even focus on the matter. Even also, when you have a look into literature, you will probably find only a very, very small number of articles on the necessary harmonization of inheritance tax in the EU or other problems of inheritance tax under the EU law aspect. Well, in principle, that 100% majority obstacle could be avoided by a clever trick, because the EU treaties allow the member states to agree on an enhanced cooperation. That means if the member states agree that progress should be made in a certain field of legislation where they cannot march forward with the consent of all the member states or cannot reach the necessary agreement of all states which are needed, then the EU treaties allow the smallest amount of member states to march forward alone and to issue EU legislation only for that number of states which want to make progress in that area. Now the surprise is that cannot only be done for entering new fields of EU legislation into the treaties, but it can also be done in areas where the treaty gives already a competence to the EU and where you cannot obtain the necessary majority votes in the Council to pass legislation for all the member states. So the 100% majority which is needed for a directive on taxation could be avoided if those member states who want to agree on a harmonization apply or announce that they are going for an enhanced cooperation. So if 20 states, for example, wanted to issue a tax directive, they could design this in form of an enhanced cooperation. So the resulting directive would be applicable only for these 20 member states which take part in that enhanced cooperation. And the others would have the right to opt in the course of time or stay apart. That this could be done in the field of taxation has been tested already. There is a proposal to introduce legislation on a harmonized tax on financial transactions. There, the application for an enhanced cooperation has already been approved by the Council of Ministers, although the necessary 100% agreement of all the member states taking part in that enhanced cooperation could not yet be reached because they have quarreled over the details of such a tax. But that case showed an enhanced cooperation in the tax area would be possible. The only condition which the treaties pose is that at least 9 member states take part, so that at least 1/3 roughly of the member states go forward with a kind of core Europe, and then the rest is allowed to follow. So it would be possible, probably, if you had some member states interested in that. If not, you end up with a race to the bottom effect, so that in the end, everyone will end up with, in all probability, a zero rate on business property. If you do that and don't abolish inheritance tax completely, then you have a situation that business property is zero taxed and private property is, for example, taxed with 30, 40, or 50% inheritance tax. Then the important problem for any tax system will be to draw a line between private and business property in a way that this is consistent, convincing, and can be defended. Now, the problem with property is you can always sell it and then reinvest it. So naturally, if you feel death is coming, you would try to sell all your private property, or at least to use all your money in a bank account to invest it into business property for the rest of your life, then die in peace and without any inheritance tax burden, so that afterwards your heirs could inherit only, in the majority, mostly, only business property, tax-free, and later then change that business property again into private property. If you really want to set up rules which avoid this simple trick, you end up with highly complicated rules which can never really strictly defend the line and which are really, really complicated to control. For example, Germany does this, and if you see the German rules on the tax exemption for business property and the conditions which are combined with that, then you lose all your faith into humanity, because highly complicated, very strict and intransparent conditions to be held by the old and new business owners. And in the end, when you apply it literally to many constellations, a chaos comes out. So let's draw a conclusion, or let's sum up. If you really end up with a zero rate on business property and still tax private property, then you will in all probability either allow arbitrary tax saving for people who are clever, so that is no longer a taxation according to the ability to pay, but according to the ability to think. Or you end up with highly complicated rules, which are highly difficult to comply with and to check. So your tax will probably in the end be a failure. Now, the rich might prefer that, because if that tax breaks down and doesn't work, good, at least in the short term. In the long run, what happens if you really end up with not taxing the rich, but instead taxing the poor in a higher extent? If you want to know what comes out in the long run, take a history book. Very often, if you had an elite which refused to take part in a decent part in paying their part of the fiscal burden of a state, that fired back, because that's a very good marketing for very socialist ideas. It does not really produce fans of your system. If poor people see that they are poor and have to pay taxes, whereas the rich get away absolutely free of tax, that endangers the legitimacy of a social system, and that is a very, very bad effect in the long run. So investing a bit into a decent inheritance tax might be a very good investment for wealthy people in the long run, because it upholds the legitimacy of the present conditions of ownership. And so it might be avoiding social costs. Well, okay. So when we speak about a zero tax for business property, and also then still a tax on private property, we end up with some constitutional problems. For example, in Germany. Here in Germany, the constitution demands that equal things shall be treated equally under equal circumstances, because everybody is equal before the law. This is Article 3 of the Grundgesetz, the basic law, the German constitution. And we have a constitutional court which has the power to apply this principle to review simple state legislation, or ordinary state legislation, and it can declare a state law as unconstitutional, so that it is either directly suspended or that the parliamentary institutions get the binding order to review and change it in according to the constitutional requirements within a given period of time. Now, inheritance legislation has been a constant battlefield between the Constitutional Court in Germany and Parliament and government on the other side during the last 20 or 30 years. For example, the Constitutional Court began with being not satisfied that the value of property was measured by different standards, although in principle every property has a market value. And so they demanded strongly that the rules for the measurement of property at a given date should be reformed. And later, business property was privileged and real estate property was privileged. Later, the new rules again privileged business property and real estate property. And so again, after a while, when new complaints came up and went their way up to the Constitutional Court, again, the new legislation had to be changed in accordance with the constitutional requirements. They demanded equal treatment of property with equal value, and they said exceptions need a justification and exceptions need to be restricted to the cases where they are absolutely necessary. So again and again, the inheritance tax legislation in Germany was cancelled or criticized by the Constitutional Court, and reviews and updates were demanded, and the political actors always reacted by following the orders of the Constitutional Court only in the absolutely necessary extent and still upholding privileges. But when the Constitutional Court more and more insisted in that privileges for business property would be restricted to the cases where they are really necessary, drawing the line between private property and business property and defending that line against tax abusive or tax avoiding behavior grew more and more complicated, so that at the moment we have a highly complicated inheritance tax law just due to these restraints. On the other hand, the Constitutional Court is absolutely right in its demands, because taxing business property not and private property fully, that gives a strong incentive for tax-saving models for changing private property into business property artificially. And so the line between the two kinds of property must be defended strongly. But this leads to complications. Now let's turn to another question: the impact of EU state aid rules for inheritance tax. As you perhaps already know, EU law forbids any state aid to enterprises. If it's not explicitly allowed in the treaties, any state aid granted by a member state um, which distorts or threatens to distort competition by favoring certain undertakings as they formulated shall be forbidden. The Commission can nevertheless, in certain cases, allow a state aid if it's compatible with certain exceptions laid down in the treaty. Now, a state aid is any measure where a state gives financial aid to enterprises, to selected enterprises. So you must prove that this is not a general state policy like a low corporation tax rate. Nobody can prove that this is something exceptional, but every measure where only a few or not every enterprise can profit from can be viewed as a state aid. So when one now has a look to what is the German state of affairs at the moment. In Germany, we renounce on taxing business property at the moment by inheritance tax, but it is restricted only to that cases where it is deemed as necessary in order to secure the survival of the enterprise. So it is now turned into a measure, the, the business exemption is now turned into a measure which is no longer available for all enterprises without restriction, but only for a few of them. So there is a selective effect of that tax exemption. And the selection is even done under the aspect that only those enterprises get the tax advantage which needed to survive in the market. And this is basically the core element which constitutes state aid. So it could be highly plausible that the German inheritance tax exemptions could be qualified as a state aid, and the German state institutions have, as far as it is known publicly, never asked for the EU Commission's approval of these rules. So that probably if a court qualifies them as a state aid, then they could not be protected as permitted by the EU against any critique from EU law. If that were ruled in court, then it would have the automatic effect that the German business property exemptions in the current German inheritance tax law would legally never have existed, because if they are a state aid and have not been allowed by the EU Commission, then legally that rule never has any effect. So there is indeed a huge potential impact of EU rules on inheritance tax law. If that also has an impact on the, or if that is if there is a comparable situation in the legal situation in other states, I personally do not know, but at least the risk should be known and should be checked whenever you have to deal with inheritance tax of other states, which are especially favored for enterprises and which do not generally cover all enterprises without exception. Yeah. Last but not the least important point when it comes to the relevance of EU law for inheritance tax is the impact of the fundamental freedoms of EU law. You remember them: freedom of capital, freedom of services, freedom of establishment, freedom of goods, free movement of workers, and freedom of movement of other persons. As I already reminded you, the member states have the right to design their tax laws freely, but they have to keep in mind that they can't design their laws in a way that the rules of EU law are impacted in a negative way. So they can choose every inheritance tax system which they want to choose, but the system must be designed in a way that it does not impact negatively the freedom of capital, especially the freedom of establishment or the freedom of movement. So let's first bring back to our minds what these freedoms say. They forbid two things: the discrimination of the persons involved on the ground of their nationality. So it's not allowed to tax an EU citizen more heavily than somebody from the inland, citizen of your own state. And it's not allowed to restrict one of these freedoms unnecessarily or to restrict them in an unjustified way. Such a restriction is by standing jurisdiction always defined as any measure which makes the usage of one of the freedoms less attractive. Now, less attractive logically requires a comparison, and the standard comparison which the European Court of Justice uses is the comparison with the equivalent inland case. So a restriction can be rephrased in a simple way as, in most cases, a restriction is just a discrimination of the cross-border case in relation to the inland case of the same nature. So we have basically two effects of a fundamental freedom. The discrimination of the person involved is forbidden, and the discrimination of the transaction involved, of the behavior involved, in comparison to the inland situation. Yeah? Now, why can inheritance tax at all affect these freedoms? Shouldn't one see it in a way that dying is a very personal matter and has nothing to do with economy? Indeed, that argument has been brought forward when the first cases came to court. Well, dying, where's the economic aspect? That can't have to do with the freedom of capital or so. But on first glance, that's true. On second glance, it's rubbish, because the fundamental freedoms do not directly address dying and inheritance. That's clear. But if an inheritance tax law exists that influences your behavior during lifetime and the behavior of your heirs, and that is the impact which might impact the fundamental freedoms in a negative way. For example, you are 50 years old, so half of your life is already over. You want to buy a house. Now you know that if you buy a house in the inland, the house will later, due a specific tax exemption, go completely untaxed to your spouse or your children. Such a legal situation really existed in Germany some years ago. Whereas if you bought that house abroad, some 30% or so of the value have to be paid over to the fiscal authorities, so that probably your heir cannot keep that house. Now, the question is, will you then prefer a house in the inland, or will you prefer the house 10 meters beyond the border? And the answer is clear. If you know about the legal situation, that gives you a very strong motive to invest only in the inland. So although dying is a very personal and non-economic matter, at least I hope so, if you are not a professional killer, that's true. So although dying in itself is a very personal matter, the knowledge about your inheritance tax law influences your economic behavior. It keeps you away from investing abroad, and so it constitutes a restriction, because the decision to buy a foreign house leads to higher tax consequences than buying a house in the inland. So the cross-border transaction is discriminated against the inland transaction of the same nature. Or, example number 2, you live in Germany, your closest relative is your daughter. She lives close behind the border in the Netherlands. You own 2 houses in Germany. value 400,000 together. Now, if you die, in that moment, the case is covered by unlimited tax liability in Germany, because Germany says unlimited tax liability cases are all those cases where one of the two persons involved lives in the inland. Now, an inheritance between parent and child is under unlimited tax liability free up to 400,000 euro. So, in my example, at the moment, as you live in the inland, the full free allowance of 400,000 will be granted, so no taxes will have to be paid. And that's it. Now you get older and older and weaker and sick, and your daughter offers you to move to her house. She is going to take care of you. She and her husband are willing to keep you in the house and care for you, and so you avoid moving to a care home for old and retired people. Now, if you know about the tax situation, you have one idea in mind. If you now move to the Netherlands, you cancel your German residence. So there will be no unlimited tax liability for the future inheritance tax any longer. The free allowance will go. It drops down for limited tax liability cases to only 20,000. Indeed, that was a legal situation in Germany some years ago. So they later had to change it. Why did they have to change it? Well, here in our situation, moving to the Netherlands will just worsen your fiscal situation in a way that later your daughter will have to pay some 100,000 additional taxes probably. And knowing that, will you then really move to the Netherlands, or will you try to avoid this at all costs? So in that situation, the specific design of that German rule infringes or inhibits or restricts your freedom of movement to another EU state, doesn't it? Because if you move, huge financial damage. If you hold on living in your home in Germany, that's not the case. And that entirely is caused by details of the German legislation alone. So it can be reproached to Germany alone. It's not an effect which just comes from the existence of different laws. It's entirely caused by the German legal system alone, so it can be called a restriction. Again, if you buy a participation of 30% in an EU-based company, you can remain free of inheritance tax if you fulfill certain conditions for the business investment exemptions under German inheritance tax laws. Now, if you buy the same participation of 30% in a company which has a PE or which has permanent establishments at all the same places, but is not registered in an EU country, but has the registered office in a non-EU country, then you do not qualify for such a treatment. So then your shares are fully taxed when they are inherited by the next generation. Does this knowledge about this rule influence your behavior before you die? Naturally, it does. If you have a choice to buy a 30% share in a foreign company or in an EU company, you will always decide for the EU company. So, does this affect your free movement of capital? Yes, it does. Investing capital into a foreign company gets far more unattractive. By the way, sometimes you have an overlap between the scope of application of the free movement of capital and the freedom of establishment, and the line is usually drawn there in a way that one says the freedom of establishment is touched when the participation grants you an influence or a certain and safe influence on the behavior of the enterprise, on the entrepreneurial decisions. That probably is the case with a 30% exemption. So this would also come into the scope of the freedom of establishment. This is important because usually if the freedom of establishment can be restricted or denied under the treaty, the rules for freedom of capital investment respect that. So if you have rules which do not grant the freedom of establishment with respect to a certain country, then you usually cannot claim equal treatment with the argument that also affects freedom of capital. Only if a rule is not specifically aimed at majority or influential participations, but at every participation, even the 0.1 participation, then one would have to qualify it as addressing the freedom of capital, and then the freedom of capital could be invoked in your favor. Yeah, so from the examples, you can see that inheritance tax can potentially violate the EU fundamental freedoms, and so that you can criticize the present state of legislation in court successfully in such cases. Nevertheless, if you have the suspicion that something might be a discrimination of a person on the grounds of nationality, either openly or covertly, or if a transaction is discriminated so that the cross-border event is treated less favorably than the identical inland transaction, then such a thing still can be justified by compelling requirements of the legal situation. So if you have that suspicion there might be a discrimination on grounds of nationality or a discrimination of the cross-border transaction, then the next step will have to be check for compelling justifications. And yeah, compelling justifications would have to look on the following aspects. Forbidden discrimination requires unequal treatment of different persons under the same circumstances, and only the relevant circumstances for the situation, for the problem count. And no compelling justification must be there. And one important thing is if there is really every other relevant aspect identical, then it's hard to believe that any reason for a compelling need to differentiate the treatment can still be found. So whenever you are able to find an absolutely comparable inland situation or an absolute comparable situation where an inland citizen is treated better, then you have already brought forward sufficient proof that there can be no justification. So probably condition number 3 and 4 are two sides of the same coin. If you can find a difference in the relevant circumstances, then this can require a different treatment. On the other hand, if there's really no difference in the relevant circumstances at all, and such difference can be imagined, then it's absolutely rare that an exception or a justification could show up. There is only one case where this might happen, where the treaty has a special rule which explicitly allows a differentiation in comparable circumstances. But that is very, very rarely the case. If you deal with the discrimination of a cross-border transaction, so with a restriction, then you have to test it in several steps. First, you must establish that it is really a restriction, so that the local law treats differently the cross-border event in comparison to the inland effect. And then you must compare with four-step test, and the justification is only possible if all of the four tests can be passed successfully. The first one is the measure must have a legitimate aim that can be any aim of the public interest which is not contradictory to an EU policy. Naturally, EU law cannot tolerate a national legal measure which has the explicit aim to bring down the functioning of an EU measure. But every other aim would be legitimate. So if a state policy follows the aim or has the aim to increase the number of free living elephants in the garden of suburban people, this would be a nonsense aim, but nevertheless it would be legitimate under EU law. It does not aim at counteracting an EU policy. The measure in question must also be able to reach or serve this aim, because a measure which is not apt to reach its aim, a measure which cannot have any success, does not deserve to be upheld against the EU freedoms. You don't need to tolerate nonsense rules. The measure then also must not be excessive, so it must not exceed the necessary amount of restrictions imposed on the fundamental freedoms. So a state which thinks it must take a certain measure must choose that measure which has the least negative impact on the freedoms of the persons involved. Yeah. Now the problem is, what is the least possible impact? And there different states can hold different views. You cannot oblige one state to follow the discretion, the decisions of another state. The only thing which you can bring forward is that this state, by its own behavior, has already accepted that a certain lower restriction, a lower amount of reaching the aim is tolerable. That can be proven if you can find an exactly comparable inland situation where the state is satisfied with a lower level of protection for that aim which it wants to reach. So if you can prove that a comparable inland situation is treated less strict, then it is sufficient proof that the legal system of that state can live with a lower, less excessive restriction. And last but not least, the measure must not be discriminating arbitrarily, which is not here aiming at different treatment according to citizenship, but is meant in a wider sense. There shall be no arbitrary differentiations, that the law treats a cross-border case in a strict way, so that it enforces the aim in a very strict way, whereas it is very liberal in the inland case or in any other case where the same problem arises. So if you are strict and exact in the cross-border case, but don't care about the problem in a comparable inland case, then this also proves that your legal system does not really require to be strict. And then the measure which you take for the cross-border case is not sufficiently justified. This argument with the comparable inland case is sometimes presented under the keyword of the principle of recognition, so that a state recognizes by its own legislation that being so strict as it is in the cross-border case is not necessary for the functioning of its legal system, evidently because they are more tolerant in other cases. Yeah. Now, the matter becomes interesting when you leave the area of the EU and look to relationship with third countries. There is a first group which has an interesting special status, that is the EEA countries, the countries of the European Economic Area, namely that is Iceland, Liechtenstein, and Norway. And there the fundamental freedoms of EU law are fully established under the EEA Treaty. So the European Court of Justice would also enforce the obligation for non-discrimination of persons and non-discrimination of cross-border events in all cases where they relate to an EEA territory. Naturally, under the condition again that the circumstances are comparable to an inland case or an inside EU case, because non-discrimination requires equal comparable situations. Now the European Court of Justice has, in relation to the EEA countries, ruled that there might be one difference in the legal framework, namely that the EU directives for cooperation and exchange of information between the fiscal authorities does not apply automatically to the EEA countries. And they said this creates a difference in the legal framework applicable to the case, which might justify to treat an EEA case differently. But they said, if now an EEA country has made an agreement with an EU country which guarantees a comparable extent of exchange of information between the two countries, then this difference is gone, and then the situation is fully comparable, so that then the non-discrimination principles fully apply in relation to these EEA countries too. Especially Germany has concluded double taxation treaties with sufficiently wide clauses on information exchange with all the three EEA states. Liechtenstein was the last one, established exchange of information in 2013. Since then, there is no possibility for Germany to bring forward that the exchange of information situation justifies a different treatment for investments in or persons from EEA countries. So from the German perspective, under the non-discrimination rules, or for the application of the non-discrimination rules, Iceland, Liechtenstein, and Norway are to be treated exactly like EU countries. Yeah. And now let's go on to that fascinating country in the middle of Europe, Switzerland. Switzerland is neither a member of the EU nor a member of the European Economic Area, but Switzerland has established a bundle of treaties with the EU on a bilateral basis, and there much of EU law has been indirectly incorporated into Swiss legislation. So especially by treaties between the EU and Switzerland, natural persons have the full freedom of establishment in both parts, both contracting parties. So EU citizens have the full right of free establishment in Switzerland, and Swiss citizens are fully entitled to freedom of establishment in the whole area of the European Union. Interestingly, it has been decided, what is by the way true, that the freedom of establishment for a natural person also comprises the right to set up a capital company in the other country, because the freedom of establishment gives a natural person the right to either become active by a head office in another state, or by a permanent establishment, or by a subsidiary company. So if you have a company in Switzerland which is held at least by a majority participation or even 100% participation, that is clearly making usage of the freedom of establishment by the investor, and so it would be protected as in the same way as the freedom of establishment would grant rights within the EU, so no discrimination allowed for such an activity. The freedom of capital is not granted in the Swiss treaties, but the freedom of capital is granted with regard to all territories by the EU treaties themselves. See Articles 63 to 66 in the Treaty of the Functioning of the EU. The freedom of workers is granted between the EU and Switzerland, again in the treaty between EU and Switzerland. So you have in many areas full compatibility between the EU and Switzerland. Now again, one might bring forward that a lack of exchange of information might justify a difference because the legal framework is not completely identical. For example, if the taxpayer states something and the tax authorities of an EU state cannot ask the Swiss authorities for checking the information and confirming its authenticity, that might make a difference in the application of tax laws. But if that is not the case, so if there is a sufficient cooperation with Swiss tax authorities, which allows to check the authenticity and the facts of a case with the help of the foreign tax authority, then the difference in the legal framework does no longer exist, and then the freedoms can fully be invoked also in relation for Switzerland. But what is very important, the Swiss treaties do not cover all the fundamental freedoms, so you must really look for something in the treaties EU-Switzerland which effectively covers the thing which the person in your case did. So one situation which I could imagine would be a worker from Germany takes up a job in Switzerland for a long, long time. Now, living in Switzerland in a rented home is probably not convenient in the long run. Rents are high, so our worker decides to buy a home in Switzerland to live there. After having worked there for 15 years, the worker moves home to Germany and later dies. Now, the house in Switzerland is still unsold, inherited by his daughter or son. And daughter or son have also moved to Switzerland in order to take a job up there. And they continue to live in that. Now, our worker has definitively made usage of the right of free movement of workers. This right is granted by the Treaty EU-Switzerland. Discriminations and restrictions are forbidden, and it is even explicitly stated in an annex to the treaty that this also covers tax rules. So, if the acquisition of that house in Switzerland can be seen as connected with the job in Switzerland, and common sense says it probably is, then this event is also protected in present and future by EU-Swiss treaty rules on the freedom of workers against any discrimination or restriction. Now, let's compare buying a house in Switzerland with taking up a job in another city in Germany instead and buying a house there. Then it would be clear that leaving a family home to a child, if that child then continues to live in that family home, the child could invoke a tax exemption. Yeah. Now that family home has been in Switzerland and the child goes on to live there. So if the exemption were applicable in the Indian case, it would be denied in the cross-border case. So we suspect discrimination. Now, I'm not absolutely sure, I always forget that, if our family home must be lived in by the deceased until the last moment, or if the deceased can have used it as a family home and then left it. Don't know for exact. But if that is the case, that in an inland case, this could be qualified as a tax-free transfer of a family home to the next generation, then it makes no sense to deny that exemption for a Swiss case, because Switzerland here is comparable to an EU state, because the reason why that happened was that somebody used the freedom of workers to take up a job in Switzerland. The only way to escape that conclusion would be to ask the European Court of Justice if it were possible to see the acquisition of a house in Switzerland in our constellation as not connected, as not being a consequence of taking up the job in Switzerland. And now imagine if the court would rule it's not connected, then that would mean the right to acquire a house in Switzerland does not follow from the freedom of workers granted to such people. So that would imply that a person who takes up a job in the other area has, although that person lives there for 20 years or 30 years, never has a guaranteed right to acquire a house in that new territory. And that would be highly surprising. And I think the European Court of Justice is probably not willing to concede, to accept that view. Huh? Another aspect, relevance of EU law again for Switzerland. Imagine now somebody doesn't move to Switzerland at any time, no freedom of establishment is used, no freedom of work, but a German investor just invests 500,000 into a house in Switzerland, and this house is let to tenants. Now, if the house were located in Germany, only 90% of the market value would be subjected to tax. We will hear about that later. As it is now located in Switzerland and not in an EU land, 100% would be taxable under German inheritance tax. Now the question is this as a restriction? And the answer is, first look if any fundamental freedom applies. Freedom of workers does not. Freedom of establishment does not. The only thing is, this is a capital investment. So yes, freedom of capital applies, but the freedom of capital with regard to third countries is not fully granted. There are a bundle of exceptions in the treaty. For example, the most important one is a standstill clause in Article 64, that the provisions of Article 63, so free movement of capital, do not affect the application of any restrictions with regard to third countries, if these or as far as these exceptions already existed on the 31st of December 1993. That was the moment when the freedom of capital was enshrined into the legal framework of the EU treaties themselves. This exception only applies to direct investments, that is, freedom of establishment cases. So direct investment is entrepreneurial investment. So portfolio investment is not named here in the exception. The provision of financial services or the admission of securities to capital markets, there differences can be made. And even then, if we don't have such a thing, there are possibilities that the Council can introduce new restrictions or tolerate them. Article 65 says in a declaratory way that the member states can apply provisions of the tax law which distinguish between the places and the taxpayers if they are not in the same situation. That does not allow discriminations. That just clarifies that in the field of tax law, not every distinction according to the residence or to the place where the events happen is automatically um, a discrimination. Article 65 has been enlarged by a fourth subparagraph some years ago that the Council has the right to adopt a decision which allows the introduction of restrictive tax measures with regard to third countries. But this has not yet happened with regard to Switzerland. So if we, on the ground of that, with that background, check our case, then the first thing is freedom of capital might be granted here, third country investment. The standstill clause nevertheless allows the application of any restrictive measure in national tax law, which already existed on the 31st of December 1993. Now, the 90% tax valuation rule would be skipped by German law if it did not exist already at that date. It would be tolerated and upheld by EU law if it already existed at that date. And so here it might be promising to check exactly the history of the law which applies today. We have heard in the meantime several cases in the European Court of Justice where the ECJ had to decide what is an existing law at that point of time and what is a new rule which did not yet exist but replaced a former restriction. Introducing new restrictions after the date for the standstill clause would not be allowed, so abolishing an old rule and replacing it by a new rule automatically makes the new rule illegal. Yeah. We could also again bring forward if there is a sufficient exchange of information with other countries. Freedom of capital is granted with the exception of the standstill clauses and the other few exceptions mentioned in the treaty. Very often the fiscal authorities can try to justify that the legal situation, the legal framework is not the same because the exchange of information is missing and therefore the situations are not comparable. And if the comparability of the situations does not exist, then automatically you can have no discrimination in equal situations. So any argument which you might bring forward falls down. On the other hand, if you can prove that there is a sufficient exchange of information and there can be no other relevant difference, then you have equal situation. And if the rule in question is not older than 1993, then automatically the discrimination is forbidden if it cannot be justified with compelling reasons. So you can also bring forward EU law with relevance with regard to investment in third countries when it comes to inheritance cases. Yeah, good. Now what might be a good task for you and me to do, especially for you to do, is do some research on the homepage of the European Court of Justice. And there try to find out a comprehensive list of all the cases where the ECJ has spoken on the compatibility of inheritance tax rules with European Union law. And for example, have a look on questions like for which countries has already the applicability of EU law been acknowledged? Which arguments have already been disproven, so rejected by the court. And just for practical reasons, make a full list of all the cases in the way how one usually cites ECJ cases, like you do it as European Court of Justice of 22nd of November 2018, case C, so court case 679 from 17, so brought forward in 2017, and then give the name of the plaintiff or the person most affected by the case. Yeah, make a list, read the court decisions, and then get a feeling on how the European Court of Justice deals with inheritance cases. If you have the feeling you don't understand what's going on, that's natural, because it's very often about foreign law. But the foreign law is, and the relevant EU law is always outlined in the beginning of the court decision, and later the important point comes where the court brings forward what the parties used as their arguments, and then the court shortly makes a comment if that argument can be accepted or that argument must be rejected and for which reasons. They usually do it in very short, decisive sentences, but they nevertheless give good information on which arguments might be accepted and which might be not. It's a highly interesting lecture, and you should get used to it as quickly as you can. Now, we have passed a first overview about everything which regards the overall design of a text and the underlying problems. Now you have a feeling for the problems: distortive effects, EU harmonization, problematic but necessary, negative impact on equity, liquidity, and so on. And so let's look for potential solutions. At the moment, the legislating bodies of many states usually react to things which they regard as a hardship provoked by inherited tax by granting tax exemptions for that specific situation. For example, in Germany, there are tax exemptions for a family home which you pass on to your spouse or to your heirs if they continue to live in that house for a minimum period of time, for business property, for many other situations, always under some conditions, sometimes very complicated ones. The number of these exemptions or exceptions has been increasing always strongly over the decades. The idea is usually, somebody is by the tax forced to sell a part of his property which is especially valuable to that person. That's cruel, that's a hardship that must be avoided. So that is a basic misunderstanding of the character of that tax, because, well, if you decide to levy a tax on property and not on income, it is inherent to such a tax that the person whom you tax has to give away a certain percentage of that property, so that you have to part with some assets. You have to get to give them away. You can't keep everything. So even if you like your property, and most people like every item of the property, there will be that cruelty. It's built in the conception of such a tax that such a person has to give away a bit of the property, or even have to sell parts of the property. So the effect that you cannot keep all your property is just built in. It's the natural effect of that tax. And now, if you once agree to levying such a tax, you can afterwards not say, but we want that tax, but we want to prevent the effects of that tax to happen. That's a bit contradictory. So You cannot regard the effect that somebody has to sell parts of the property in order to pay the tax. You cannot regard that as a hardship. That is just the ordinary everyday effect of that tax. Now, if you regard this as a hardship depending on which item is affected, then you create arbitrary differences between different people with different property. I don't know if that can be justified. So, example. Imagine a taxpayer who inherits a house with a value of 1 million. That is the house in which his father and mother lived all the time. And the taxpayer A has spent his whole youth in that house. So it's connected with very emotional, nice, moving memories for him. The tax rate on that property would be 10%. This is just an invention in order to make the example more nice. So the tax due would be 100,000 euro, and as you did only inherit that house, 1 million, you have to sell it because you need money in order to pay the tax. So you have to sell your family home. You lose it to others. Surely that's not a very nice feeling. Now imagine taxpayer B. That taxpayer inherits a house with a value of only 500,000, and the other 500,000 are inherited in cash in a bank account. Now the tax is again measured on the basis of 1 million total inheritance, and the tax would again be 100,000. Now this taxpayer has enough cash to pay that tax. So this taxpayer can keep the family home and go on living there where he lived during his youth. This is naturally a far better feeling, surely. Now, is that a reason to distinguish for taxation between the two? First, naturally, the basic effect is if you grant a tax exemption to taxpayer A, every old person will take great care that everything he or she owns is invested into a family home and that there is no cash at the moment of death. So that there is grave hardship for the heirs and that everybody shows pity. This is probably not a good effect. And the second, now look to that situation and the arguments a bit more with common sense. First of all, many people experience the day when they have to go away and part with the home of their youth. And most of them survive this experience. It's never a good feeling to move out from your family home where you grew up. But a huge percentage of those people who never parted with the family home of their youth later end up as reliable clients of psychotherapists. And if one asks somebody working in the field of psychotherapy about the mental health effects of continuously not parting with the place of birth, the psychotherapists will probably tell you nice, impressive stories about the people who cling to their homes where they have been born or lived during their youth. So, is it really desirable to give incentives for people never to move out from the home of their parents? Think about it and think about it twice. If you ever left the home of your parents, you showed some independence and grew up. Now, do you really want to establish a tax rule which brings people to move back into the house of their parents? Interesting. Second aspect. Now it is indeed possible to keep one's family home if there is enough other property which you inherit and where you can pay the tax from. So one could even be able to save money during the years before, and the money which you need to pay for the future inheritance tax. So if I am somebody who is 30 years old and who is expecting to inherit a home with a value of 1 million in 20 years, I might really save up some money, enough money which I need to pay the tax for that home if I inherit it later. My parents might even help me with that and also save up some money. So at the end, we might be able to pay that. It might even be possible when the case arises, that I go to a bank and borrow the 100,000 euro, pay off the tax, and then pay off that credit in small installments. Now you might say, but what if the bank doesn't borrow me money? And the answer is, well, your parents, when they built that house, probably borrowed the 1 million and paid it off completely. So if you cannot even go and borrow 100,000 and pay it off over the next 30 years, answer me a question. Do you really deserve to live in such a house? Nearly everybody who buys a house will have to pay the necessary amount off by installments of, let's say, 1% or so, usually over the next years, usually over the next 20 or 30 years. So what do you really think? Do you deserve if you are not able to pay off a small fraction of a house value during the rest of your lifetime? Do you really deserve that? Evidently, you probably are somebody who is really not fit to keep such a house if you are not even able to pay off 10% or 20% of the value of such a house over your lifetime. So, or what did you do with all your money in the meantime? Waste it? And now you claim pity by others? Strange idea. And the third and more fundamental idea, should really tax exemption based on how the tax affects the feelings of taxpayers? It is so hard if somebody has to move out from a house. Naturally, but if you owe income tax, will the fiscal authorities come and confiscate everything which you have, especially your house? Yes. So does it really convince to say, we want to spare the feelings of the taxpayer? And if so, did you forget perhaps that a tax is not a donation to a charity organization, that you don't pay taxes voluntarily, so that taxes always cause bad feelings? And if you have to part with a bit of your money, usually that hurts. It's always a hardship. For example, who decides then which feelings have to be spared and which not? Isn't that rather arbitrary? For example, there are people who love their money and don't love their houses. Think of Scrooge McDuck. The man loves money more than any member of his family. Taking away a single coin from Scrooge McDuck brings that man to hospital. So you would never be able to love your family home more than Scrooge McDuck can love a single coin in his money bin. So what is your justification to say, nevertheless, the coins are taken away from Scrooge McDuck, but the house we renounce on, because that was a family home. So if you want to understand the basic problem, read some Donald Duck stories, and read especially the stories which treat the topic that Scrooge McDuck has to pay taxes. That is real drama. Shakespeare cannot cope with that. So there are also hardships on feelings inflicted. It is not a reasonable aim to spare the feelings of other people that ends up in shielding people from reality and living in an artificial world. It's highly unhealthy to shield people from negative feelings, because feelings are feedbacks on reality. And sometimes you just have to cope with reality. It is not possible to say we finance a state budget based on only nice feelings. That only works if you have a population of people without any feelings. So you would be taxed in the end based on your ability to feel and not on your ability to pay. And that's highly unpopular, or that's at least not the majority view, and it should not be. So granting exemptions for cases where you say, we should tolerate that, or we should spare the people the necessity to part with a part of their property, that's the wrong solution. And it leads to more and more exemptions, and so to more and more injustice done to the others who cannot convince Parliament to grant them an exemption. So, what can you do instead? Well, if you look to the real problems, then you see having to sell a bit of your property is usually an inbuilt effect of the tax. There is no reason to avoid that. But the economic problems usually don't come from that. The economic problems usually come from the liquidity consequences. Something happens suddenly, unforeseen. You cannot really plan for it, and it affects a considerable amount of money at a short notice. So the problem can perhaps be, or the real problem is that liquidity problem. You receive message from a hospital, relative has died, and now you have to hand in a tax declaration and to pay considerable amounts within a short period of time. That is the real problem. Your ratings go down brutally at the same single moment. So, and you need to obtain cash with short notice. So under a systematic point of view, probably helping the taxpayer does not really require tax exemptions, but it requires helping the taxpayer with the liquidity problem. And so an adequate solution should address the liquidity problem. And liquidity, that would mean, think about the due date for paying the taxes. That would be a solution. So if you really inherit a house with 1 million and having to pay 10%, so 100,000, the problem is not to pay 100,000. If you could pay it off in small installments without interest, no problem. Everybody can do this. It's a very small monthly rent equivalent. The problem is you have to pay these 100 at one given due date. So giving relief to the taxpayer, sufficient relief, would already be if you say taxpayer has the right to pay off the installment, the 100,000, the 10% in equal installments every year, let's say of 1%. That would be 10,000 per year. That is something which is just the equivalent of a monthly rent. Should work. Or if you need to take up credits for that, you have ample time to do this. Or if you need to sell, you can afford to wait some years until you get a sufficient satisfactory offer for your property. No problem. At least no real hardship is left over. The additional advantage of such a liquidity solution would be you can grant it to everybody. You don't need to think about every individual situation, because you can still declare everything taxable and then say, Irrespective of where your tax comes from, you can pay it off in small installments which are granted by law. Now, naturally, you can then not bind this liquidity solution to the question if there is a peculiar hardship on the taxpayer, because such rules in practice never work. Fiscal authorities always deny that your case is a hardship, so you would have to argue with them over some years that you don't need to pay immediately. Until you win, you have to pay immediately. And so that is just the effect which would not work for people where the situation is a hardship. So you should design the tax in a way that liquidity problems can never arise and that everybody gets that liquidity saving or liquidity sparing solution. So my suggestion would be a good inheritance tax would one be where you are assessed, a tax claim comes out, 10% on all which you inherit, and then you have to pay for the next 10 years 1% of the tax base each year. Or if your tax rate is 30%, then you are busy for the next 30 years with paying off 1% of the tax base for each year, so that the liquidity drain can never become too high for you. And such a solution would also grant relief for another aspect, because a big economic problem is that inheritance tax cannot be foreseen sufficiently. Now imagine you turn to this liquidity saving installment solution where somebody has to pay 1% each year. Then the uncertainty strongly vanishes. Imagine the owner of your firm is already 82. Now, under the traditional systems, you always have to keep the risk in mind that 30% or so of all the property must be paid over at short notice to the fiscal authority. But you never know when. So that will cause high costs to take precautions against this. Now, in the other system, where tax exemptions are not granted but liquidity is saved or spared by granting automatically installments of, let's say, 1% always, then well, you must take care for the possibility that in the future you will have to make regular payments of 1% of the equity of the enterprise to the fiscal authorities. Now, if your owner is at the moment 83, you are not sure if you have to pay that 1% next year. You cannot be sufficiently sure that you have to pay that 1% when owner is 84. But you can sufficiently rely on having to pay that 1% starting from when your owner is 86 or 87. So when it comes to your planning of your financial cash flows in the future and planning a budget, you probably will, just for the sake of certain of probability or so, or just to be on the safe side, you will probably introduce the possibility of having to pay 1% in the future from that date onwards. And if it does not happen, well, having to change your plans and being happy about that the 1% payment is not yet due for this year because owner still lives, that is usually then a happy surprise. So that would work for the enterprises. It would be a viable solution without requiring that you claim a tax exemption, that you have to follow huge constraints and conditions for the next 10 or 15 or 5 years, that all your business policies are reviewed and assessed as positive or negative by the fiscal authorities. You could just avoid all this by opting for, by designing your law in a way that you assess the tax once and then demand the payments in equal installments. And it would even be a very simple solution, because if you just say everybody then pays off 1% installments of the tax rate until the full tax claim is paid off, then it would even not matter how far distantly related or how closely related the heir is to the enterprise owner. So you would not have to adopt or marry somebody just in order to reduce the tax rate. If you just say we have to calculate with 1% for a certain period of years, that probably would be, you could stand that. So that would be a far more realistic solution. And surprisingly, nobody in the literature seems to have brought it forward, because the people always say there are hardships, we must give relief to that situation, but they don't think about the situation in general. And in general, you always have a liquidity problem. You always have to part with part of your property, or you have to obtain the necessary money from somewhere else, for example, from a credit. And with such an installment-based solution for the tax, you would probably be able to finance the current installments either from current income or from taking up small credits, or from selling selected parts of your property. But then after a sufficient period of time where you can wait for satisfactory offers from interested buyers. And so the most hardships which might be inbuilt in a tax on property, tax on wealth, would automatically be reduced to the minimum amount. And so it would even be a possible solution where people might agree on in the EU, that you might say we all agree on such a 1% installment-based solution, because that would simplify life for people everywhere. And if there are then differences in the number of years which you need to pay off that additional amount, well, that would at least restrict the impact of the inheritance tax to equity, to a smaller amount than today, and make the conditions for competition more equal than they are today. Good. That was my remarks today. I hope you enjoyed this lecture a bit. Although I suspect, as it is always with tax cases, that the focus is not on the word enjoy, but the focus is more on the a bit. And I hope to see you soon again. We are going to continue this lecture on international inheritance tax with a second chapter and other chapters in next week, few weeks, don't know. And until then, I wish you the best and hope to see you back soon. Thank you for listening. Have a great day and go away.